Thank you. Good afternoon, everyone. So I'm Jisella, and I'm going to be starting by looking at some of the amendments made to the Environmental Planning and Assessment Act, which came into force on the 22nd of May of this year. They've been described as being the biggest changes in the last 40 years to the Act. I'm going to focus on three main areas because there were quite a number of changes, but I'm going to focus on amendments made relating to concept DAs, amendments relating to modification applications, and various amendments which impact community participation. So our first big change relates to concept development applications. Those of you from smaller councils may not have to deal with concept applications at all, or very rarely, because they are usually in relation to quite large projects and generally done in the cities. So by way of refresh, a concept development application is, as the name would suggest, an application which seeks to outline and lock in broader aspects, a concept or vision of a development, typically establishing a building envelope, but it can, but doesn't have to, establish other aspects of the development. For example, the number of stories, the number of car parking spaces. It really depends on the application you're dealing with as to how much is locked in by the concept. A detailed proposal is then put forward in subsequent development applications. So in recent years, there's been a number of cases handed down in the Land and Environment Court which consider the meaning of the words in section 4.24 of the EPA Act, which I've highlighted in yellow on the screen, which said that any further development application could not be inconsistent with the concept approval. So developers needed to be cautious because once the concept application was approved, they would be locked into that concept design. To change the concept design would then require a modification application, or if the amendments were significant, potentially a fresh concept application to be made. Marsden's has been fortunate enough to be involved in a number of the cases over recent years in the Land and Environment Court. The most notable, though, would be the decision of Justice Moore in the matter of Castle Hill Panorama Proprietary Limited and the Hills Shire Council, which in 2023 related to detailed development application that was lodged following a concept approval. So on the screen is a photo of the development that was ultimately approved. Originally, the concept was for 5 residential flat buildings, and the developer, through the concept consent, locked in the number of stories, parking, the maximum heights, percentages of open spaces, so quite a lot of the development was locked in by the concept. Then appealed in relation to the detailed development application, and this is what the case dealt with. Through the court appeal process, there were quite a number of changes to deal with the contentions and respond to issues raised, which resulted in there being differences to the heights of the buildings, the number of stories. They sought to introduce a neighbourhood shop, which previously hadn't been there. And as a result, there was an inconsistency between the concept approval and the development application. So as it happened, there was agreement between the parties in the proceedings, but the jurisdictional issue of section 4.24 of the Act, in terms of the words I showed you earlier about subsequent applications being inconsistent with the concept approval, arose, which the court needed to have regard to. In order to facilitate the detailed development being approved, it was necessary for the concept approval to firstly be amended. And in this case, Justice Moore agreed that the amendment could be facilitated through the imposition of conditions of consent on the detailed development consent, which required the modification of the earlier concept approval. So you'll see Justice Moore's quote on the screen, which confirms that the power to modify an earlier development consent by way of a condition does exist, and he describes the process. It was in light of this decision in particular, and I think it was even in this case was even mentioned in the first reading speech, that the New South Wales government sought to amend section 4.24, which it did through the introduction of a subsection 4, which is highlighted in red on the screen. So subsection 4 seeks to confirm that the approach taken by Justice Moore in the matter of Castle Hill Panorama is available to allow the modification of a concept approval as a condition of consent imposed on the approved detailed development application. Subsection 4 also goes a step further, and it provides an avenue of imposing a condition of consent for the surrender of the concept consent. Whether or not that would be appropriate, I suppose, would depend on the circumstances, whether or not that concept approval had any further work to do. For example, if the detailed development application only dealt with a portion of the concept approval and additional detailed development applications were envisaged to deal with the whole of the concept approval. So if it has work to do, it may not be appropriate for it to be surrendered. The next amendment I'm going to discuss relates to modification applications, and I imagine by now we're all familiar with the Court of Appeal decision in Biozo and Ku-ring-gai Council. The decision of the court fundamentally altered the long-held understanding of the modification powers in Section 4.55 and Section 4.56 of the EP&A Act. It was previously believed that they were available to modify any aspect of a consent, even mere conditions. But the court held that there are conditions or limitations on the exercise of power to modify a consent, for example, by looking at the substantially the same development requirement. So these conditions or limitations demonstrate that it is the development to which the consent as modified relates, which must be modified before the power is engaged. In other words, the modification powers are only available where some change is proposed with respect to the development for which the consent was granted. In the case of Biozo, the applicant sought to amend conditions of consent to reduce the amount of contributions that it was required to pay, because this was based on the calculation of gross floor area, which was found to be incorrect. But because this modification application didn't affect any change to the actual development, the modification power was not engaged. So in that case, they could not just amend the conditions of consent. It was in light of this specific decision that the decision of the Court of Appeal in Biozo that the New South Wales Government has now amended sections 4.55 and 4.56 of the Act to introduce new subsections highlighted in red on the screen, which expressly gives the consent authorities the power to approve modification applications which only seek to modify conditions of consent, even where there would be no change to the development, the subject of the consent. And you can see the same change reflected in 4.56. There's also been a number of other minor amendments which relate to this particular amendment. Changes to section 4.55 subsections 1A and 2 were also made that replace the requirement for the development to which the consent as modified relates be substantially the same. This has been changed to a requirement that it be the same or substantially the same, presumably to reinforce that no change to the development is necessary to approve a modification application. A further minor change that's been made is to section 4.55 subsection 1A. So this now allows modifications involving no or minimal environmental impact. So the words no and or have been added in there, which just acknowledges and addresses the court's position in Biozo that a modification or deletion of a condition may have no environmental impact. Finally, I'm going to discuss some amendments to the Act relating to community participation. The first change I'll be discussing relates to the notification requirements for State Significant Development, or SSD, which are found in Section 9 of Schedule 1 of the Act. Section 9 of Schedule 1 has been amended now so that the minimum public exhibition period for SSD is 28 days, or for a relevant SSD application, if there is a relevant community participation plan, which specifies a period of public exhibition for the application, then that period as specified in the plan. There's also a definition for relevant SSD application. It means an application for SSD that includes residential accommodation or housing development carried out by certain public authorities, infill affordable housing, build-to-rent housing or seniors housing. Now, with the introduction of the Housing Delivery Authority, we are seeing quite a number of developments being declared as state significant development. So this change in the notification requirements will become increasingly relevant, although not so much of an issue that councils need to deal with on a daily basis, because notification of SSD is primarily managed by the Department of Planning and Environment. Of more interest to council is the second amendment relating to community participation that I'm going to be discussing, which relates to submissions. And this change that's been made responds directly to a decision handed down in 2024 in the Court of Appeal. In the matter of Philatron, it was originally a Class 4 jurisdictional review appeal which related to council's approval of a DA. The applicant, Philatron, argued, and the court agreed, that the approval of the development was affected by error. So in this case, Philatron had provided a submission outside of the original notification period, and that was done with the agreement of council. That becomes relevant then in the judgment. The objection raised a number of issues, and the assessing officer considered these in the assessing report and indicated that in their view they could be dealt with by conditions of consent and provided details of those. However, when the notice of determination was issued, they didn't carry through those conditions into the determination. So an appeal was lodged by Philatron, and the court agreed in the Class 4 matter. Justice Robson found that the assessing officer had failed to consider statutorily mandated matters of Section 4.15 of the Act, and therefore failed to properly determine the DA. Council had argued that because the submission was made outside of the submission period, the notification period, that the decision wasn't affected by error because it didn't need to take into consideration that submission in any case. But the court found that even if a public exhibition period has finished, the council must still take into account any objections received as public interest matters. And then this went to the Court of Appeal, and the Court of Appeal agreed and found that Section 15 of Schedule 1 did not say that submissions may only be made during the minimum public exhibition period. So in response to the Court of Appeal's decision, the government has specifically amended Section 15 of Schedule 1 of the Act, which governs the mandatory community participation requirements. It's inserted subsections 3 and 4, which are highlighted in red on the screen. And it now makes clear that whilst a submission received outside of the notification period may be considered by the consent authority, it's not a submission for the purposes of the Act. And the first reading speech explains this change is really important because it provides clarity, particularly where the number of submissions determines who is the relevant consent authority. Okay, and I'm now going to hand over to Peter Hudson, who's going to talk to you about biodiversity.
Good afternoon, everyone. Peter Hudson. I'm a partner at Marsden's. David indicated I've been here for 23 years, so clearly I started when I was 10. And I've been here since I graduated from university. My son's now doing his HSC, so that 23 years really has flown by. I'm going to talk to you about the recent amendments to the Biodiversity Conservation Act, pursuant to the Biodiversity Offset Scheme amendments. These came into force, and most of them are now in force in March of 2025. In particular, I'm going to take you through three specific areas of amendments: the avoid, minimise and offset changes, the government's intention to transition the biodiversity offset scheme to net positive, and cash contributions to the Biodiversity Conservation Fund. The government's intention when it brought in the amending act was given in the second reading speech to protect what is left, restore what has been degraded, and transition to a nature positive approach for biodiversity in New South Wales. It acknowledged that nature in New South Wales is declining and must be set on a path to recovery, that the avoid and minimise hierarchy be strengthened, and that changes be made to ensuring offsetting is genuinely used as a last resort. And it's been acknowledged that that's not happening at the moment. Now, my intention was to just simply take you through the amendments, but I appreciate that not everybody here is familiar with the Biodiversity Conservation Act. It's a complicated piece of legislation, and key terms such as what is a BDAR, what is the BOS, and what is the BAM are all important things that you need to consider. I'm going to be looking at the amendments from a planning perspective as well, so particular focus for the local council clients here in terms of what happens when you lodge a development application. How are these amendments changing your assessment of applications? So an application for development consent, in short, must be accompanied by a Biodiversity Development Assessment Report, or a BDAR for short, when a proposed development is likely to significantly affect threatened species. So when you receive a development application, if it relates to land where there's vegetation, and I'll get to the definition of that shortly, you need to carefully consider whether a BDAR is required. If a BDAR is required, the biodiversity offset scheme applies, and these changes will be significant. So what is likely to significantly affect threatened species? There are 3 tests. The first one is if a development is likely to significantly affect threatened species or ecological communities or their habitats, according to the test applied under the Act. Now, for some of you who are familiar with the previous iterations of the EP&A Act, this is the old 7-part test. So you look at the site, things such as, is there a viable population of species on the site that will be placed at risk of extinction? That type of impact is going to cause there to be a significant effect on threatened species, and a BDAR will be required. The second test is whether the development exceeds the biodiversity offset scheme threshold, which itself is determined under the biodiversity regulations. Basically, that's twofold, that test. Firstly, is there clearing of native vegetation above a certain area, and that area depends on the size of the lot. Or secondly, is there clearing of native vegetation from land that is on the biodiversity values map? So you should make yourself familiar with whether the biodiversity values map applies to the site, and you can view that map on the eSpatial tool. If you're able to get onto that, good luck with that. What is native vegetation, and what does it mean to clear native vegetation? Those definitions, curiously, are found in the Local Land Services Act. They're not in the EP&A Act, it's not in the Biodiversity Conservation Act. You need to go and look at the Local Land Services Act. So native vegetation means any of the following types of plants that are native to New South Wales: trees, understory plants, ground cover, so that can include grasses, or plants occurring in a wetland. Clearing of native vegetation includes cutting down, felling, uprooting, thinning, or otherwise removing native vegetation, or killing, destroying, poisoning, ringbarking, or burning native vegetation. So if, as a result of a development application, you are doing any of those things to anything that falls within the definition of native vegetation, you're going to need a BDAR. I was recently involved in a case that got all the way to day 1 of the hearing, where we attended the site. It was a large rural site, application for a single dwelling. A BDAR had not been lodged in support of the application because the dwelling was not touching any trees. But when we arrived at the site, it became apparent that the driveway that needed to connect from the road to the dwelling didn't remove any vegetation, but it was going under trees, and it was going to result in grasses being destroyed. It became apparent that that would involve the clearing of native vegetation above the threshold of clearing that's identified in the Act. So the applicant was faced with a situation where they have a DA on day 1 of the hearing, they don't have a BDAR, they promptly discontinued. So you really need to carefully consider when you receive a development application, is a BDAR needed? Because if it is, these amendments are relevant, and Part 6 of the Act becomes very important. The third test for determining whether there is a BDAR is whether there is development carried out in an area of outstanding biodiversity value. There is a definition of that. I've never dealt with an application where there are areas of outstanding biodiversity value, but that's something that needs to be considered as well. If you do need a BDAR, it must be prepared in accordance with the biodiversity assessment method That's the BAM. I'm sure many of you have heard of the BAM. Put very simply, and if you ask AI to give you a definition of the BAM, it's a set of rules to assess the impact of development on biodiversity and enable the determination of required biodiversity offsets. So when you employ your ecologist to prepare the BDAR, they need to really carefully consider the BAM, because if it's not prepared in accordance with the BAM, that BDAR can be declared invalid and you've got a development application that's not properly made. So once we determine whether a BDAR is needed, the biodiversity offset scheme in Part 6 of the Act applies, and these amendments become relevant. The avoid, minimise and offset hierarchy. So prior to the 7th of March 2025, when these amendments came into force, when a BDAR was required, the applicant was required as a threshold issue to demonstrate that appropriate and sufficient steps have been taken to avoid or minimise biodiversity impacts. So if avoidance of the impacts were not possible, a proponent could instead demonstrate compliance with the Act by minimising impacts. The amendments to the Act introduce a new avoid, minimise and offset hierarchy to development applications for which a BDAR is required. So firstly, the introduction within Section 1.3 of the Act of the purpose. There is a new purpose to establish a framework reflecting the avoid, minimise and offset hierarchy. And that hierarchy is now defined in the Act. Previously it wasn't. So under the new hierarchy, a BDAR is required to demonstrate, firstly, that the proponent has taken all reasonable steps to avoid the impacts of the development on biodiversity values. Previously, if avoidance wasn't possible, and I'm sure every developer will tell you that avoidance is not possible, they need to put that building where they're proposing, they need to remove that tree, they need to remove that bush. If avoidance wasn't possible, there could be a minimisation of impacts. But now, the first step must be that a developer must demonstrate in the BDAR, and as part of their application, that they have taken all reasonable measures to avoid the impacts. After it's been demonstrated that those reasonable measures have been taken, the proponent is then to take all reasonable measures to minimise the impacts that have been avoided. Having taken the measures to minimise the impacts and avoid into consideration, the proponent can then take the biodiversity conservation measures under the biodiversity offset scheme to offset or compensate for any residual impact. And there is now a definition of residual impact on biodiversity values. Now, importantly, apart from introducing Section 6.3A into the Act, the government has not yet made the regulations which set out assessment standards, identifying what genuine measures to avoid and minimise constitute. So those regulations will be made. There'll be a suite of changes to the biodiversity conservation regulation or an alternative regulation, and we await with keen interest what those regulations will entail. Essentially what that means is this change, this introduction to the hierarchy really is the first step in the process of the government's intention to focus on the avoidance of impacts rather than simply allowing applications to either avoid or minimise. A developer cannot simply adopt a minimisation strategy first. Now, when I was looking at the new 6.3A, I was actually also at the same time preparing a statement of facts and contentions for a Hawkesbury matter. Hi, Craig. And I was looking at the Hawkesbury LEP clause 6.4, which is a common it's a common clause in the in the standard instrument, referred to as the terrestrial biodiversity clause. That clause is in most local government or most local environmental plans, and it applies to land that is mapped as ecologically significant, and it mandates itself an avoidance and minimisation strategy. So notwithstanding that you have a development application where a BDAR may not be required, if the land is still mapped as significant under the LEP, most councils already have the avoid and minimise strategy in place, and a development application will need to identify that as part of the application and as part of the ecological assessment, which won't be the BDR, submitted in support of that application. If a BDR is required, it will have to also comply with this. The court has not yet dealt with or made any comment on the new avoid minimise hierarchy. There's been an acknowledgement of the new section 6.3a in some recent decisions, but other than acknowledging that it exists and agreeing that particular applications that have come before the court have identified that there has been sufficient measures to avoid impacts on native vegetation, there's been no commentary on what would constitute avoidance and what would constitute a genuine attempt to avoid. Okay, transition to net positive. So the government, in introducing the amendments, has identified that it has an ambition to transition the current biodiversity offset scheme to net positive, to improve biodiversity in New South Wales and not allow it to simply be maintained or declined. What's the biodiversity offset scheme, you might ask? So put very simply, it's a scheme, it's a system where developers can compensate for the negative impact of development on biodiversity by funding conservation actions elsewhere. So it aims to ensure that development does not lead to a net loss of biodiversity. And now the government is started the process of ensuring that it will not only be net loss, it needs to be net positive. There is a new section 6.2a that's been inserted into the Act, but quite frankly, that's all that's happened so far. There's a new section which talks about what the minister can do and what it should do, but nothing's happened yet. So 6.2a essentially requires the minister to make a strategy for the transition of the biodiversity offset scheme to deliver net positive biodiversity outcomes. Public consultation of that transition will be mandatory, and the minister must make the strategy as soon as practicable after the commencement of the section. So the section commenced on the 7th of March. I've just put an extract of it on the screen. Commenced on the 7th of March. We're now the 20th of June. I'm not sure what the government sees as soon as practicable, but from what I can tell, there's been no commencement of any action to identify what this transfer or what this transition to net positive will entail. I appreciate it's going to be complicated, and I wait to see what the government does. Section 6.73 of the Act has also now been amended or introduced. There. And it requires the minister, when establishing the biodiversity assessment method, so that's the BAM, which I spoke about earlier, it's how you prepare a BDR. So when establishing that method, which undergoes changes quite often, the minister must have regard to the strategy for the transition to deliver net positive biodiversity outcomes under 6.2A3. And in doing that transition, adopt a standard that will result in no net loss biodiversity to New South Wales. So overall, the government is just bringing in at this stage this concept of a transition to net positive, and that will permeate into how BDRs are prepared and what must be considered when they are prepared. So with these amendments, as I said, there's no immediate change in practice, but they will pave the way for future change. So lastly, the amendments to the Act also change the way the Biodiversity Conservation Fund works. And I'll put quite simply, at present a developer who is required by a development consent to retire biodiversity credits may satisfy that requirement instead of retiring credits and physically finding elsewhere for the vegetation or the vegetation that's lost to be planted, they may instead pay an amount into the Biodiversity Conservation Fund. The government recognised that the Biodiversity Conservation Fund currently operates as a default pathway for many proponents, but it sees that should be a last resort, not a first resort. So we don't get to the point where you have to retire credits, we'll just pay some money, cause the damage on the site, and we're done. The government's preference is for genuine attempts to actually address that biodiversity impact rather than paying into the fund. The cash payment is determined in accordance with the offset payments calculator, and this is presently the way the legislation works. This has been a feature of the biodiversity offset scheme due to the difficulty of acquiring credits in the open market to retire. Where you've got a very particular species that you're trying to offset damage to, it can be very difficult to find like for like to offset that damage. So there's an opportunity to pay money into the fund to offset that. So in short, landowners have not embraced opportunities to create those credits, and there's simply no credits available to purchase. Hence, a payment is made into the fund. So the amendments to the legislation will now allow the government to make regulations which limit the ability for a developer to pay cash into the Biodiversity Conservation Fund in lieu of retiring credits. Those amendments haven't been made yet. So the amendments to the Act simply allow the government to make legislation which limit the ability. We are yet to see what will entail from that. So a takeaway from these amendments, we can see what the government's trying to do, but it really is a work in progress. Real changes to the scheme are yet to be seen, but they're certainly foreshadowed, and the aim is to achieve a net positive status for New South Wales. So it's a watch this space. Thank you.